the Nnamdi Kanu case has now entered into another very surprising situation. The Nnamdi Kanu case has entered into another level. In fact, those that want Nnamdi Kanu to be sentenced and jailed and even possibly eliminated are working hard. But then there are people that are insisting and giving out reasons, cogent reasons why Nnamdi Kanu cannot be convicted, cannot be sentenced, cannot be sent to prison. That's what we gathered. This news dropped like few seconds ago, and we're bringing it for you here in Noble Media. If you have not subscribed, go ahead and click on subscribe right now. Let's move on. Nnamdi Kanu can't be convicted under repealed law. Lawyer fault terrorism trial. Amid moves by the leader of the indigenous people of Biafra, IPOB Nnamdi Kanu, to halt the scheduled November 2025 judgment in his terrorism trial, a legal expert has declared that the court cannot convict him under a repealed law, that it is impossible for Nnamdi Kanu to be convicted. Justice James Omotosho of the Abuja Federal High Court fixed the date to deliver judgment in the trial, which has lasted several years. This matter started 2015. From 2015 to 2025 is about 10 years that this matter has lingered, and Nigerian government has not been able to come up with a valid reason to sentence Nnamdi Kanu. Kanu and his defense team have been arguing that the Terrorism Prevention Amendment Act 2013, under which he was charged, had been repealed by the Terrorism Prevention and Prohibition Act 2022. So, the law upon which Nnamdi Kanu was captured and charged is no longer in effect, is dead, has been repealed by Nigeria, not Nnamdi Kanu, by Nigeria. By the lawmakers in Nigeria, they decided that that law no longer fits in, and they repealed the law. Therefore, they cannot stand on a law they say they no longer want to convict an innocent man. We must move on. In a release on Wednesday, Christopher Chidera, a member of Nnamdi Kanu's Global Defense Consortium, argued that it was wrong to prosecute Nnamdi Kanu under a repealed law, and as a result, he can be convicted based on non-existent status. How can you convict a man like Nnamdi Kanu, or even anybody, on a law that is no longer existing? That is an abnormality, and that's what this lawyer is talking about. Where do you stand? If you are one of those that believe that Nnamdi Kanu deserves to be free, if you are one of the lovers of Nnamdi Kanu, you need to understand that his enemies are many. His enemies are also working hard. So, if you want Kanu to be free, come under the comment of this video and type "Free Nnamdi Kanu now." Tinubu release Nnamdi Kanu now before it is too late. Omotosho, do the right thing. Omotosho, do the right thing. Don't allow yourself to be used. Release Nnamdi Kanu now before it becomes too late for you. Somebody type it in the comment section. Okay? Not one Nigerian court, from the Supreme Court to the High Court, has ever sustained a trial on conviction under a repeal status. Every non-attempt was quashed as a nullity. That is in the past, too. Why are they not now following the same thing in Nnamdi Kanu's case? He argued that there can be no conviction without a written law in force at trial, and faulted the court for proceeding with the IPOB leader's prosecution, despite what he described as glaring evidence that the law under which he was charged had been repealed. Noting that the presiding judge, Justice James Omotosho, failed to provide an answer when Kanu asked why he is being prosecuted under a non-existent law, the lawyer declared, "Today, the question is answered definitely, constitutionally, and jurisprudentially." Pay attention, no? Noting that the presiding judge, Justice Omotosho, failed to provide an answer when Kanu asked why he is being prosecuted under a non-existent law, the lawyer declared, "Today, the question is answered definitely, constitutionally, and jurisprudentially." Pay attention, no? It's important people know this. Please share this video. Let our people know what is going on. There is no single instance in Nigeria since 1999 where a criminal trial, conviction or plea was sustained under a repealed law. Since 1999. None exists. None can exist. A repealed criminal statute dies ab initio. It cannot sustain a trial, conviction or plea unless explicitly served by the repealing act. Saved by the repealing act, and even then only for truly pending proceedings. Pay attention though. Please come under the comment of this video and type just so motor show. Don't allow yourself to be used. Releasing Nnamdi Kanu now. Type it and share this video. Click on like too. Or motor show. Don't allow yourself to be used. Free Mazi Nnamdi Kanu now. He further argued that statutes such as the Terrorism Prevention and Prohibition Act cannot override provision of Section 36, Subsection 12 of the 1999 Constitution, which forbid concession for any offense not defined and enforced at the time of trial. Under Section 122 of the Evidence Act, counts must judicially notice repeals. Failure to do so is not mere error, it is a fraud in the Constitution. Chidera asserted. The question is, and many people even in the international community, for some of us outside Nigeria, and for some of us inside Nigeria, the question has always been, why is it that Nigeria do not want to obey their own laws? They do not want to obey their own constitution, except when it involves the rich, the wealthy, the business people. But for the ordinary masses, they do not obey their constitution. Under Section 122 of the Evidence Act, courts must judicially notice repeals. The Mazi Nnamdi Kanu defense team further observed that a sweeping search of Nigerian and global legal record shows no instances where a repealed law sustained a criminal trial, conviction, or plea. It's very important. Citing the case of Abacha vs. State 2002, the lawyer averred, repeal extinguishes offenses. Savings cannot breathe life into what is already dead. So Kanu cannot be held under a dead law. It is not done anywhere in the world. It has never been done in Nigeria. It has never been done outside Nigeria. And why can it now be done in Nnamdi Kanu's case? If you don't believe this, explain yourself. If you're a lawyer or you believe that Nnamdi Kanu already committed offenses, explain to us in the comment section. We need to know. Also citing federal government versus Osahon 2006, he insisted no prosecution survives repeal. General 7 cannot revive repealed offenses. Charges are struck out, accused, discharged. Stressing that offense not defined by extant law is unconstitutional, he added, in every case, repeal ended proceedings. Courts discharge accused persons, struck out charges of voided convictions. No trial proceeded to a valid conclusion under a repealed law. Not once. That it can never happen. It has never happened. Why do they want to make it happen in Mazi Nnamdi Kanu's case? No person shall be convicted of a criminal offense unless that offense is defined and the penalty prescribed in a written law in force at the time of trial. Once repealed, the law is no longer in force. Any charge under it collapses ab initio. This is what Nnamdi Kanu was acting on motor show in court by 7th of November when he was in court. In fact, Nnamdi Kanu got annoyed. He roared. Here in Noble Media, I will share that video for you when he was asking, show me the law. Show me the law in Nigeria that can convict me. A written law. Omotosho cannot stand upon nothing or upon a directive by those in power, the enemies of freedom, the enemies of Biafra, to convict Nnamdi Kanu. Nnamdi Kanu is saying it's not possible. Arguing that Section 6 of Section 1A of the Interpretation Act cannot override the Constitution, the lawyer noted that by the provisions of Section 122 of the Evidence Act, courts must recognize repeals automatically. In the same vein, he noted that ignorance of repeal voids jurisdiction, adding, records of proceedings show that till date, Justice Omotosho is yet to take judicial notice of the repeal of the Terrorism Prevention Amendment Act 2013, a fatal error A fatal error in law. So why is Omotosho doing this? Somebody come and say, Omotosho, don't allow yourself to be used. Releasing Nnamdi Kanu immediately before it becomes too late for Nigeria. Omotosho, don't allow yourself to be used. Releasing Nnamdi Kanu right now. According to him, when an appellate court orders retrial after repeal, the new trial is a fresh proceeding, not a continuation, as a repealed law cannot revive the charge. Let's move on. Mazi Nnamdi Kanu stands charged under the Terrorism Prevention Act 2011 as amended, that's 2013, a law repealed by the TPPA 2022. The repeal took effect on May 2022. The fresh arraignment and the novo trial commenced December 2023. Therefore, at the time of trial, the repeal status was not enforced. By constitutional compulsion, that law equals to that case. The trial is nullity. Any plea or conviction thereunder is void ab initio. Chidera added. The question is, do you think Justice Omotosho is ignorant of all this? Or do you think he knows all these things and he is allowing himself to be used in the Nnamdi Kanu's case? Or is he afraid of anybody? Insisting that the court cannot convince Nnamdi Kanu, the lawyer declared, repeal case prosecution totally, instantly, and irrevocably. To proceed under a repeal statute is to conduct a trial without law, an act forbidden by Section 36, Section 12, and condemned by precedent. This is the way it is at the moment. Of course, here in Noble Media, we are following up on this matter for you. So share this video, like this video, click on join to become a member of our channel. And most importantly, there's another video very important on the screen. Click on it and watch now.